authority and filed a motion to dismiss in this court based on the holding in Johnson, which we believe was correct.
Can I ask you about that, though? So assume I agree with you that Johnson forecloses some of the forms of relief requested in the complaint. I don't see how it forecloses all of them. So Johnson, as I read it, says, whether you call it jurisdiction or something else, this court or no federal court has the authority to basically engage in appellate review. So you can't remand because we're not doing appellate review. But that doesn't mean but on the other hand, their complaint asks for the court to order compensatory education. I don't think that's foreclosed by Johnson, is it?
Johnson does not foreclose compensatory relief.
So there's no basis for dismissing their whole case under Johnson, is there?
No, Your Honor. What they've asked, the relief requested is an annulment and a remand.
Sure, and I understand that Johnson, I don't think, allows the court to order that. But it doesn't, so they ask, I'm looking at their complaint, it says award compensatory education. I don't think Johnson prohibits that. Award them costs, expenses, and attorney's fees. Now, they have to be prevailing to get that, but Johnson doesn't foreclose that. Grant other further relief as the court deems appropriate, doesn't foreclose that, right? So at most, Johnson forecloses some of the forms of relief they've requested, right?
No, Your Honor, I don't think it does. I think if you look at the complaint, my memory is that it was compensatory relief to be provided by an ALJ on remand. So it kind of contemplates that, again, and I think you just heard it from the appellants.
Right. It is contingent. Your argument is that the compensatory education requested is contingent on the remand. Right? That its own remand. And so that request is not an independent request for the district court to order it, but is instead for it to be part of the consideration on remand.
That is correct.
Which would make sense. That's what your colleague on the other side says. Yes, we agree. If you can't remand, which Johnson says you can't remand, then we're done.
And it's not just Johnson. It's Johnson, it's Kirkpatrick, and it's also this court's recent opinion in KI, which affirmed Johnson just less than 2 months ago. So, I think the bigger concern for this court is all the arguments you just heard, none of that was in any of response to CMS's motion to dismiss. To the extent there's any circuit split or any other authority that would contradict Johnson, that was not raised. And the first time that that's been even discussed is 5 minutes ago.
Counsel, maybe it's not asked here, but Johnson wouldn't foreclose a parent and a parent student bringing an original IDEA case, seeking the relief available under that statute, nor would it preclude a claim that a state's procedure is contrary to to the federal statute. In other words, not allowing remand or appellate type relief, as I recall from Johnson, doesn't preclude original action cases to enforce the statute's requirements. The question is what relief is sought, and here, and I am somewhat sympathetic to the appellant because Johnson came out after the complaint was filed, but at least as the request for relief is, arguably it doesn't seek relief that we can now provide.
I would say the complaint in Johnson is almost identical in terms of relief requested as the...
Well, it's true, but the facts were different. I want to, the facts were different as the response to the motion to dismiss points out. There was a mootness issue. There was, but anyway, I'm not sure that's worth going on. My main point was, I'm not sure Johnson precludes a plaintiff from obtaining, the benefits of the federal statute. It has to be sought from the district court rather than a remand. Do you agree with that?
I'm not 100% sure I understand exactly the question. What I will say is...
Well, so how about putting it this way? Say the complaint rather than... I pulled it up. Candidly, I'm a little confused what the reference to remand means in that section of the complaint, but assume for the sake of argument that you wrote a complaint asking the district court to grant compensatory education that says nothing about remanding to an ALJ. It just says, request for relief. The district court should order compensatory education. That's what I want the district court to do. Do you agree that Johnson does not foreclose a complaint that says that?
If it was properly,
Yeah, right. We're properly exhausted. It's properly presented. I proved a violation of idea. And district court, when you agree with me that I have a proper idea claim that wins on the merits, the relief that I would like is that you, district court, order the defendant to provide compensatory education. Do you agree that's not Johnson would say nothing to prevent you from doing that?
Johnson speaks to the relief requested.
Right. And here the relief requested is, I want the district court in the first instance to order compensatory education.
What federal district court judges are empowered to do, and this is in the plain language of IDA, I mean, they're empowered to receive the records from the administrative court. They are empowered to take additional evidence at the request of either party.
Sure.
Either party has requested additional evidence. So
right.
That is not on the table. And then
But what's the answer to his question? I'm sorry. This question matters, right? So let's go back and answer that question. Then explain it if you want to. But the question is, if they just ask for compensatory education, Johnson would not be a bar to their complaint.
I think that's correct, Your Honor.
Correct.
I
Okay.
mean, Johnson says that specifically,
Right.
doesn't it? I mean, there just wasn't, it wasn't clearly pled, but it says specifically that, I'm pretty sure.
I think the reason I'm trying to be straightforward with the court is that in order to have any compensatory relief, you have to first find a denial of faith.
Of course.
Okay. Right. No, that's exactly where I wanted to go. But we had to answer that question before we could go to the next question, right? So the next question is, but to do that, you would have to find that he's disabled, and that there are multiple steps here, but that he's disabled, and that he needs these services, right? His sort of disability. He has one of the identified conditions, and he has a need for these services. But the district court would have to find that based on evidence that was given to the district court, either through the administrative record or an additional fact-finding that's made.
That would be the determination. If that were the procedural posture in that hypothetical, that would be what the district court would do.
And if instead, I guess what I'm trying to get to here is, if that's not the argument instead is, you didn't give me my procedural rights, and therefore give me compensatory education, that's not a proper claim, because it doesn't show I know we have acronyms everywhere, but either FAPE or IEP or whatever the acronym we want to use, to get compensatory education, if properly pled, you've got to show that you're entitled to an IEP. That is, you have a disability, which means you have a condition plus a need for services.
Here's the easiest way. That it's sort of a three-step process. Number one, there has to be a referral and an evaluation conducted. And at the end of that evaluation, an IEP team, which includes the parent, makes the determination as to whether or not the child is eligible. The parent gets prior written notice of that eligibility decision, and they get information on what their rights are to challenge it. And there's a 1-year statute of limitations on bringing that. At the end of that process, if they disagree, they can file a due process petition, and then that gets exhausted. If the parent does not like the outcome, or if the school board does not like the outcome, then they can bring an original action in federal court. But in order to get to that point, the crucial first step to that is that the child has to meet the definition of a child with disability under IDA. And there's a specific definition for that. A disabling condition is not enough under IDA. In a lot of Section 504, which is also a disability law, is much broader, and it allows for services and accommodations for disabled students. Not every child that gets a 504 plan will get an IEP. Have to meet.
So I get that. Before the district court, was there any dispute about whether this child was receiving passing marks and advancing grade to grade?
Was there there was no genuine issue of material fact.
Right, because the record that the district court had was he was making predominantly B's and C's, although occasionally there was an A mixed in, and that he had been advancing from grade to grade. And your point on that, I take it, is that means he doesn't meet the definition of disabled, and so, even if there's some part of this that survives Johnson, that part is eliminated because the child is not disabled. There wasn't, let me rephrase that. There wasn't evidence presented that the child was disabled. I'm not making a judgment about.
I think the two cases that are cited in our brief that the district court also relied on, you look at the Forest Grove case, which is a Supreme Court case, you look at the DeBrow case out of the 11th Circuit, they talk about only children with disabilities, that meet the definition under IDA, those are the only children that are entitled to FAPE. So if they're not eligible, then there is no entitlement to FAPE under IDA at all. If they are eligible, then FAPE is provided through an IEP. And then parent, if they disagree with it, they can challenge the substance of it or they can challenge how it was implemented. But the DeBrow case and the Forest Grove case draw a pretty clear line there that not every disabled child needs special education. And that's what the IEP team in this
let's just, I mean, here, this is hypothetical. A parent says, my child's eligible. They give reasons why. The IEP team is assembled. They look at all the evidence and they determine the child is not eligible. And let's assume that's wrong. I mean, just blatantly wrong. How does a parent get relief for their child if a IEP team misses the boat on eligibility?
Happy to answer that, Your Honor. So the eligibility is, the first step would be to file a due process petition and raise eligibility as one of the issues that you're challenging.
So is it they saw the due process hearing. Is it your position they didn't challenge eligibility?
It is, Your Honor. And the district court found that what they raised, and that has been raised several times throughout the administrative proceedings and in the district court, the fundamental claim that was raised here is a child find claim. And there's a distinction between child find and challenging the eligibility decision. Child find means... But
do you really think, I mean, I hear you. If you look at the headings, none of them really say eligibility. They messed up on the eligibility. But isn't fundamental, or isn't intertwined with all their specific legal arguments, the basic argument that her child was eligible and they made a mistake?
So let's assume that there wasn't an issue with eligibility. Let's assume that it was properly raised.
Okay.
So this is where the summary judgment aspect of these proceedings comes into play. IDA doesn't speak about summary judgment. It's silent. There's nothing about summary judgment in IDA. And as you will see, I wouldn't say a majority, but a lot of states, I think there's 7 states that are cited in this record. And the best evidence about summary judgment in terms of how it can be applied is from the appellant's own case law from the Second Circuit.
And I'm jumping ahead because I think I'm understand where you're going. If you properly challenge eligibility, I know you say they haven't, but if they either we disagree or someone does, you get to do that through a due process hearing. But you still must present genuine issues of material fact there, and there's nothing prohibited in the act that prohibits a state utilizing the rules of civil procedure.
If the district doesn't believe there's any genuine issues of material fact or there are issues of law that can be resolved, as in this case, the district can file a summary judgment motion. And as in this case, it can be responded to with corresponding affidavits. A hearing can be heard, as happened in this case. And then the ALJ makes a decision on summary judgment. That doesn't violate IDA, and it's allowed under North Carolina law. So, any claim, 30,000 feet that summary judgment is unlawful and that North Carolina's process violates IDA, at least is not a claim against Charlotte-Mecklenburg County Schools. If anything, that really is a claim against the state.
Well, no, the state decides how to, I hear you. I guess I see what you're saying. And back to one other, could, in your view, with Johnson, assuming it is, good law and remains intact, I mean, could a plaintiff say, hey, this process, this utilization of the state rules of civil procedure, which in certain circumstances can say you don't get to go forward with a hearing because there's no genuine issues of material fact. Could that claim be brought in federal district court, that the utilization of the process you have of utilizing the rules of civil procedure, which at times mean no hearings, violate this federal statute?
I don't think so, Your Honor. And
You don't think that can be brought? You don't think someone could say, hey, this whole system violates federal law?
well, let me rephrase that. I think the way that was presented in this
Yeah,
complaint,
that's not what I'm talking about. I'm talking about as a matter of theory, hypothetically, could you say, North Carolina, you undermine IDEA with the way you are implementing it?
I think that there have been cases that have made those claims against state administrative agencies, the state, not individual
Yeah.
education agencies. And there is a case cited in our brief that goes into that a little bit in detail. And also it's discussed in the JD case from the Second Circuit. In those cases, my memory is that both the school board and the state were defendants in those cases.
Yeah.
If I can, Your Honor, I think one follow-up to your point on eligibility earlier. Assuming eligibility was raised as an issue, summary judgment occurred, and there was no, on all the other parts, our brief goes into it in depth. But this is a student who had a private diagnosis of autism, just a diagnosis of autism. In order to be eligible under the category of autism for IDEA, there are several different requirements. You have to meet 3 out of 4 impairments, and the policies speak to exactly what that is. The team looked at that, found the child was not eligible. That is not disputed anywhere. Neither the affidavits, the evaluations, the parents' affidavit, none of those speak or even analyze those impairments or disagree with CMS's decision. And, Your Honor, my time is drawing near, so I will conclude briefly. So we are asking that this court grant CMS's motion to dismiss under Johnson, Kirkpatrick, and KI. In the alternative, we believe the district court's order was very well reasoned and persuasive and should be affirmed. That concludes my prepared remarks, but I'm happy to answer any other questions.
Thank you, counsel. You got some time in reply, counsel. Can you start with the question of whether the only relief you're seeking is a remand, or whether you've made an affirmative case that your client is entitled to compensatory education?
I believe, Your Honor, that the client is entitled to the compensatory education.
Yeah, which is a different question than the one I asked, right? So what I'm asking is, your complaint in the federal system, did you ask only for a remand, or did you put on evidence or provide argument that he was entitled to compensatory education? That is, he's disabled in a manner that qualifies for a FAPE IEP.
Yes, that proof was in the record reviewed by the district court.
Okay, and so what is the evidence that you put forward that he's disabled within the meaning of the IDEA?
Okay. In the record, we had an independent psychologist testify about his need based on his disability for an IEP and special education services. That was in the administrative record in response to their motion for summary judgment at the hearing level.
And your argument is that you made that argument to the district court. And so where would I find that argument?
I'm not going to have that at my fingertips. Can I follow up with the court on that?
Sure.
If I may respond to the issue of us not asking on the eligibility issue, okay? If you look at page 11 of our initial brief here, it outlines what we asked for in that hearing request. And in that hearing request, we asked specifically for that they failed to provide a FAPE and that they develop an IEP. Certainly that is identifying that we wanted the kid eligible for special education if we're asking for an IEP. So I think that rather than be semantic about this.
Can I ask a different, just a factual question that I asked your colleague? I want to make sure. Is there a dispute that your client was receiving at the time? I don't care about today, but at the time, the record reflected that your client was receiving A, B, and C's and was proceeding from grade to grade?
That is what the district's position is, and that is one of the reasons.
Is there any evidence to the contrary to that fact? I understand you want to talk about IQ and other things, but reading level, what I'm asking is there anything in the record that disputes those two facts, that the grades that he was receiving were A, B, and C's, and that he was progressing from grade to grade?
I don't dispute that that is what the district was awarding him and that he was being progressed from grade to grade.
So can I?
But this is a child with a 74 IQ. So those grades and that progression from grade to grade is either a recognition that they've erred in not giving him an IEP, or that the standards for a black boy in Charlotte-Mecklenburg are very low.
Can I go back to something Judge Richardson just asked you? So he asked, where did you ask the district court for X? And you pointed to page 11 of your brief. Page 11 of your brief summarizes the relief you requested from the ALJ during the due process hearing. Where is it in the record that you asked for that relief from the district court?
He actually said he didn't have an answer to that.
Okay,
He was
sorry,
gonna follow
okay,
up.
okay,
That was
okay.
the 11th question.
I misheard you.
11 was about Judge Quattlebaum's question.
Okay.
He said he needed to follow up on my question.
Understood.
A real concern here is that because we were denied that hearing, we were not able to address through examination of their witnesses about these grades, about his progression from grade to grade. We were not able to develop that record for the district to court to have that de novo review. And that's why
Did you seek to develop that record before the district court?
we proceeded with it through the district court with summary judgment motions, which the court ruled on
And what I'm asking is, did you ask to develop, the claim you're making, right, is that Charlotte Mecklenburg was somehow at fault for giving your client passing grades and advancing him from grade to grade. Did you seek to develop that evidence before the district court?
We did not, Your Honor, and relying on what other circuits had been doing, we believed that the record needed to be developed at that administrative hearing where there's some expertise and for example, the district court's not going to know in the context of compensatory education the programs and the services that may be available. And that's why that administrative hearing process is so necessary, where you have that expertise brought into the room.
Well, but the district court plainly can say you're entitled to a FAPE and an IEP and compensatory education, right? I mean, and can enter an order that your client is entitled to such.
Yes, Your Honor, that it can. But the details of those things are the critical element for any student. Having an IEP that doesn't provide the appropriate services, having compensatory education.
Well, but that's a different argument, right? The first argument is you got to have one. And then if they give you one and you don't like it, then you can complain that what they gave you wasn't good enough. But if you don't have one, the second argument doesn't seem to be the rub. Right? I mean, your client's not entitled to one. Right now, your client is not entitled to one. And so talking about how good it might be doesn't seem to be the right line. What am I missing there?
What I think is missing is that the administrative process, the hearing process, is set up for all this to be laid out, so that when it does get to the district court, that record is there, right? It's limited exceptions that the district court takes in additional records. Perhaps in the Fourth Circuit, every case should go to the district court to be heard because the hearing officers are dismissing things when there's issues in dispute. Maybe that's what has to happen here, but I don't think that's an efficient way to do things. I think we have to force these hearing officers to do their job. I do want to bring the court up to date about the student. It's my understanding that he is now classified by the district as of August 26, 2021. He does have an IEP. They do now recognize his autism, and he continues not to receive what I believe to be appropriate services and is still functionally illiterate.
Well, right, so let's assume hypothetically that we're going to take your factual development on the record here. Doesn't that just mean then your claim here is moot?
No, Your Honor.
Aren't we just done?
Because I think what it then means is that the district failed to appropriately identify him as a student with a disability at the time, and that since that time, he has been denied a FAPE.
Yeah, that's one way to look at it. Another way to look at it is evidence that was presented at a subsequent hearing, and they came to a different conclusion. Now, that's our problem with talking about things that aren't in the record. We don't have the whole context. And
I agree.
appreciate the information. I'm glad he's got his IEP regardless of that. So
We obviously wish that we could come down and greet you as we would typically do. It's a long tradition here in the Fourth Circuit that we get a chance to come speak. We regret that we cannot do that. We hope to resume that process in relatively short order, but we certainly thank you for being here. And we'll move to our next case, which is 22-1505, Hal Scott Magaro versus Henry McCollum.
under the retainer for 3.5 years represented these gentlemen. During that time period, as soon as we saw that there was any question whatsoever about any kind of mental incompetence or inability to proceed, the first thing we did was put a guardian in place. And that happened in Cumberland County. Cumberland County Court decided to put in Geraldine Ransom Brown, the closest living relative to Leon Brown, who, once he had left prison, failed to take his antipsychotic medication that he had been prescribed since a juvenile for the traumas that he had been experiencing in prison. Geraldine served as the guardian until she was removed by the court. She tried to take money from them. She was caught by Halscott Magaro, reported to the court. The court then substituted in a North Carolina attorney, Dwayne Gillum, to be the guardian for Leon Brown, who then served with us for the next 2 years. So a period of 3 years, 2 different guardians were put in place to ensure the rights were protected for Leon Brown. Now, Henry McCollum, his brother, was slightly older, slightly different scenario, one that we believed objectively could handle his affairs. Again, no less than 14 different judges, prosecutors, including another law firm, 3 separate attorneys that were hired. And the opposing counsel will rely on the disciplinary hearing of Patrick Magaro, which is the 800-pound gorilla in the room here. They're going to rely on that to say that we knew or should have known. That's not the case, because we were actually the second 1983 civil rights firm to come into the case. And that's
So, counsel, if I could just interrupt you, and I appreciate that. I won't give you time to go back to it, but I'm trying to understand one aspect of your argument, and it sounds like one of the things you're saying, maybe, that's what I'm trying to find out, is that the conclusions reached by the North Carolina Disciplinary Agency somehow didn't take all the circumstances into consideration and may have been wrong. And that's one way you could say, proceed maybe, and maybe you're doing that, maybe you're not. As the district court found that, the court can take judicial notice of administrative agency. It went through that test. It can, consider third parties through privity, and it went through the law there. So what I'm really trying to figure out is your argument that there are facts that pertain to the law firm that are different than pertain to the lawyer who was handling the case and who was disciplined? Or is your argument that the disciplinary proceedings didn't get the full picture?
I think it's both of those, Your Honor. Let
me just do however you want, but I'm particularly interested in the former, that how there's a difference and what would happen to pursue that. So you can make whatever argument you want, but that's the one I'm interested in.
Of course, then let me jump out with the privity issue, right? That's the big thing here, because we're dealing with 2 things, right? Patrick Magaro bad, Patrick Magaro and Halscott Magaro are the same thing. That's really the simple boiled down explanation of what is being written about in Judge Boyle's order. Privity requires a mutual interest to the same right that one party is representing as applies to the other. And this is not my case law. This is the case law from Judge Boyle and the case law from opposing counsel. I'm using all of their case law. It's very solid, but their application of the facts to it is wrong. Here specifically, we're looking at what was Magaro's interest in the DHC? Was Magaro's interest in getting paid for the case? Or was Magaro's interest in saving his law license and his ability to practice law?
So let me take a step back on the privity issue. I mean, to me, the straightforward basis for privity is, and tell me if I'm wrong, Magaro is a named partner of the law firm, and every single act of misconduct he was found to have engaged in, he was engaged in his capacity and on behalf of the law firm. Is that not right?
I don't believe that's a correct characterization of it.
Well, for example, when he signed what was found to be a fraudulent, invalid retainer agreement, he signed it in his capacity as a partner of the law firm. And in fact, when I looked at it, he signed it on behalf of the law firm, right? Is that right?
The law firm has to be the retainer. The retainer is with the law firm.
Sure. So he wasn't just some guy. It wasn't even Judge Richardson and I are law partners, and I go do something bad that doesn't involve him. I go do something bad in my capacity and on behalf of the law firm of Heitens and Richardson, right?
Richardson and Heitens.
Fair enough.
As the first named partner, I can understand the desire of Judge Richardson for having that. No, I get that argument. But here's the problem, and what I was alluding to with another 1983 civil rights law firm that came in before us. That one was handpicked by Ken Rose. Now, you've reviewed the records, you know the Disciplinary Hearing Commission, you know Ken Rose's stance on Patrick Magaro, that he didn't like Patrick Magaro, he didn't like that he was coming in to represent, he didn't like the relationship there. He went to the North Carolina bar and tried to have him removed. The North Carolina bar said, absolutely, that's out of, it's not going to happen. And this is all in the DHC transcripts.
I'm sorry, I just don't understand what this has to do with whether or not the law firm is in privity with its partner when its partner does something on behalf of the law firm.
Because we are focused, in this case, Judge Heitens, you're focused specifically on the retainer. The retainer isn't really the misconduct that...
That's part of it. They talk about the terms of retainer. They talk about then some other things such as, the loans that were done. I mean, is your position that the Magara, I hope I'm not saying Magara was acting outside the scope of his authority as a partner as one of the two named partners in the law firm?
I'm taking the position that Halscott Magaro didn't have a chance to address the retainer itself and whether or not it should have been valid and what the reasons were for the retainer the way it was. No one's ever taken issue with the amount of the retainer agreement.
But can you answer my question? Is it, and maybe this is premature, so an answer might be, I'm not prepared to do that now. But is it your position that Mr. Magara was acting outside the scope of his authority as a partner in the acts that the North Carolina Disciplinary Agency issued its decision on?
Many of them, yes, Your Honor. Yes. And again, there were about 20 different allegations, about half of which were ones that there was evidence for and half that there weren't. But not everything was, if we focus on the retainer, yes, Patrick Magaro had the retainer signed for Halscott Magaro. To this day, I still have no problems with the retainer. The retainer's language is clear. The retainer's language is not.
One of the findings is you had no business entering into a retainer agreement with a person who, according to the finding, is obviously incapable of signing this retainer agreement. That's one of the findings about what's wrong with it. When we say the retainer, I don't just mean the four corners of the retainer. It's signing a contract with a person who lacked legal capacity to sign that agreement.
That's the weird thing. If we look at the joint appendix, page 27, paragraphs 13 and 14, we look at Mike Lewis, Mark Rabill, Tom Howlett. Ken Rose handpicked them to be the 1983 civil rights case. The attorneys to handle that. And it says specifically in the findings of law, that was a contingency fee agreement. So why is it okay for the law firm that Ken Rose handpicks, but then when Ken Rose goes to the North Carolina bar and says, get these guys off the case, and then he goes to Joe Neff, who's a reporter.
Can I go back to there being no problem with the fee agreement? What about the fact that this was an irrevocable fee? That it purported to establish an irrevocable fee? You have no trouble with an irrevocable 1/3 fee or something like that?
I have a trouble with that classification of that. Now, if we were to treat that as a charging lien, which is the word that was bandied about many times, all this means, and we said it in open court, it was acknowledged to Judge Boyle, that this was exerting, that we would be able to go after them for the fees that were earned by us. That's in the case of either a breach of contract or quantum merit or an unjust enrichment, which is all of the three different avenues we tried for this. That just says, we're not going to give away our fee just because you go away. So that's not what it meant at all. And we specifically and repeatedly said this was not a charging lien. And in the 7 cases of charging liens in this case in the state of North Carolina that have ever resulted in discipline, no attorney, and they've actually said to the court, I have a charging lien. Not one of those has resulted in anything other than a warning, just an admonition. Say, don't do that, don't assert those things. So the court is going back retrospectively and asking us to have understood the entire case before we got on the case. Once we reasonably saw that there was any kind of decompensation or any kind of competency issues, the first thing we did was guardian. We put a guardian in place. And when that guardian was failing, we went and protected their rights by putting another guardian in place.
It sounds like you're, and this you're entitled to do, embracing what Mr. Magaro, did and was, in disagreeing with the conclusions that it was wrongful. And I get that. I'm understanding some of what you're saying. I may agree or disagree. But that, that doesn't seem to be to the thing I asked about earlier, which is, are you saying, we're not in privity because he was acting outside of what we do as a law firm?
And I thought I answered that, Your Honor, that some of those things were outside of it. If we're talking about him giving money for living expenses to them, which was one of the big things they nailed him on, or taking a loan to do things through Derek Hamilton, in there. Those are outside of that.
Well, so let me give you one that I've now got I was looking at. So this is JA 40. This is from the disciplinary order. By charging an irrevocable, this is the finding of discipline against Mr. McGarr. By claiming an irrevocable interest in McCollum and Brown's potential financial payments from the state, defendant charged an improper fee in violation of Rule 1.15a and engaged in conduct involving dishonesty, fraud, or misrepresentation in violation of Rule 8.4c. That is a finding by the disciplinary board that said there was something about this fee that you've agreed was done in his capacity as a law firm that was improper and violated the North Carolina rules.
The court or the district or the DHC conflates those two issues there.
Well, but that's an argument there. So I completely, as Judge Quattlebaum was saying, I completely understand that you may feel very strongly that they got it wrong, but that's sort of not how preclusion works. When preclusion applies, preclusion precludes us from asking whether someone got something wrong. And the only argument I can see for why preclusion doesn't apply is the privity argument. So unless there's not privity, I think that's just a fact about the world that we're stuck with.
Well, all of the case law that we have here says the privity requires full.
Sure, but that's an argument that they're not in privity, not an argument that they got it wrong.
Exactly. Of course I think they got it wrong. But the argument of privity that I'm making is that it requires a full alignment, and there was not a full alignment. There never was.
What do you say? I know we don't have discovery, but sitting here right now, what would you argue to me that says y'all aren't in privity?
That the law firm was unaware of some of those actions of Patrick McGarrow. He took actions outside of the scope of his duty to his clients and duty to to the retainer and duty to the law firm. And in doing so, put himself in this position. But for those actions, the DHC might have had a different conclusion. Okay, maybe this is a charging lien, but it's only an admonition, but you can move forward with it. But nonetheless, if we go further than this, the last thing I need to get in here is that this retainer was ratified. We had guardians ad litem in place for the case, and they said, no problem. We don't like.
But again, that's just, that it's relitigating the outcome of the disciplinary proceedings. And I think if you're in privity, you can't do that.
No, but the disciplinary commission went backwards in time. The case was, we're talking 2021, we're going back to 2017, 2018. The court, the guardians ad litem, in open court testified, yes, we want them to stay on as the counsel, we want them to do this work. We had attorneys, these are North Carolina licensed attorneys, one put on by Judge Boyle, who said, that's fine, we're gonna have them continue to represent. So that's where the quantum merit argument comes in there. You can't have someone represent and do the work and then say, oh, by the way, 2 years, 3 years later, we're gonna clip you and go backwards retrospectively and say, you should have known these things, even though they've all been litigated in court already.
Can I ask you
privy when we want and not when we don't.
Can I ask you two questions before you sit down about the other things, because you didn't file a reply brief? Do you have any response to the other side's argument that your request for us to review the transfer order is something that this court has squarely held we don't have jurisdiction to do?
That's an interesting one. That's a bit of a red herring, but it's there to put in the case that I've made.
Wait, your argument's a red herring, or our published authority saying we don't have the authority to do something you asked us to do?
The argument is a bit of one, because I know this court has some limitations there. However, it was important to note this whole case has been about demonizing Patrick McGarrow. When you look at the filing on getting that venue transferred, it didn't look at the factors for convenience or witnesses or any of that. It looked at Patrick McGarrow's terrible, and by the way, so is Scott Bretschneider.
Sure, but this is
admit that you're making the argument knowing that it lacks merit because you think it would sway us?
No, that's why I said I think
it sounded like you just said that you knew the argument was wrong and you made it anyway.
No, I thought that this court would be able to review that jurisdiction at any point in time.
So you just didn't know that we had a published authority saying we can't do that?
Because you seem to say that you needed to put that information in for some reason, knowing that it was prohibited.
Oh, absolutely not, Your Honor. No, but it was important. The court also knew that as part of that. That's why we didn't focus on just the factors test. We focused on the fact that they were trying to demonize McGarrow. I think the factors test is completely wrong that was used, and it should have been, it should not have been transferred in the first place. I don't think the court should have had jurisdiction.
Which court shouldn't have had jurisdiction?
North Carolina.
All right, the other question. This New York Times article that you suggest that the district court maybe possibly read that maybe super prejudiced him. What article is, it's like this article is this great unspoken thing. You say he read an article that reports some bad stuff and you think that biased him, but I don't even know what that article is. Is
Yes,
it anywhere in the record what this supposed article even is?
The article is entitled Pardon Brothers' Payout Triggers.
He's asking what's in the record.
Is it in the record anywhere?
It was discussed, yes. I believe it was discussed in the May 5th hearing, 2017, by Judge Boyle.
Well, this is the one that you say he alluded to and they claim he didn't allude to.
Yes, Your Honor. Yeah, but the other side, they seem to believe that I was talking about a later New York Times article by the same author, Joe Neff. This article was written and published in the News Observer, the Charlotte Observer, picked up by the Associated Press.
I guess my question is, did you ever, as part of your request to recuse Judge Boyle, put in the record the article that you claim prejudiced Judge Boyle against you?
It was not necessary based on the affidavit requirement.
So that's a no?
I did not put that in the record, Your Honor. I put in the affidavit under one particular section, and then, of course,
But you don't even in that affidavit say, and the article that I believe that Judge Boyle read, which is why I believe he's biased against me, is this. That the affidavit is not even named, sorry, the article is not even named in the
the article
affidavit.
was not named in that affidavit.
So we're supposed to say that Judge Boyle abused his discretion for not recusing himself because he supposedly read an article whose name is never mentioned in the record. It was not mentioned as part of your recusal motion.
No, Your Honor. There were two separate sections under which we asked for recusal, as well as the Code of Judicial Conduct. So 3 different sections. One has an affidavit requirement. One is the other one, which is just a reasonable outside person looking at this would see that it's there. Now, the affidavit supports the other one, but it may not as perfectly outline the media source that was invariably used during that time period.
You've got some time on reply. Mr. Higgins, we're happy to hear from you.
Yes, thank you, Your Honors. Matthew Higgins for defendants' appellees in this matter. So I heard 3 arguments that I'd like to respond to from opposing counsel. One was that the conduct of Patrick Magaro wasn't that bad. 2, that Patrick Magaro and Hal Scott Magaro are not in privity. And 3, that there was some sort of a ratification of the retainer agreement by one of Henry or Leon's guardians. I do before.
Can you start with 2 rather than 1?
Start with privity?
Yes.
Yes, before.
Or you can do something else first, but you can skip the bad part, right? Go to the privity piece once you get over else, whatever you want.
If I do want to correct the record about the May 5th, 2017 hearing that I heard opposing counsel reference. He said this morning, as was said in the brief, that the district court referenced the contents of that New York Times article or some other article, which, yes, were pejorative towards Hal Scott Magaro, did say facts that painted Hal Scott Magaro in a negative light. But that May 5th, 2017 hearing was about Henry's competency. There is no mention at all whatsoever about Hal Scott Magaro, their conduct or their misconduct. It's not a topic of that proceeding. As we say in our responsive brief, that is a misrepresentation of the record. We've put that in our response brief. Judge Haytens, as you mentioned, there was no reply brief filed to respond to that. It is a misrepresentation of the record to say that the district court relied on that, and I do want to highlight that at the beginning of my argument. And I will get into privity. The arguments that I heard from opposing counsel are that Hal Scott Magaro and Patrick Magaro are not in privity because they are separate entities, essentially. But under North Carolina law, a firm and that firm's member are in privity when that member's professional license is being litigated. That's exactly the Klein case, which, again, we talk about at length in our responsive brief, and which I didn't hear any reply.
So does that mean that if they say they didn't know about certain conduct. They say certain conduct's outside the scope of my authority. If you go out, on the street and do something that's completely contrary to your firm's policies and procedures, and it results in the forfeiture or your inability to, obtain some fees or something like that, is your firm bound by that?
Not if the firm's interests and the lawyer's interests diverge, but of course that is not this case.
Well, how do we know? I mean, you may be right, but if the lawyer handling the case is, providing money or arranging for loans, and those are no-goes, we don't do those at our firm, and he did it at their firm, how do we know some of those are things that are done in privity?
Well, a few things on that, Your Honor. What I heard from opposing counsel this morning about things that Patrick Magaro did outside of the scope of his relationship with Housecat Magaro. That is not in this record. That is not in the complaint. That is not in any of.
Well, that's partly, it may be, but this is a 12B case, right? So, I mean, I think one of their arguments is that if you're going to decide something on 12B, it needs to be beyond question from the pleadings or whatever else you're able to consider. And here, I'm not sure it's valid or invalid, but if hypothetically it would take you outside of privity if the firm didn't know and they were acting outside the scope of their authority, why is it okay to do that at a 12B6 stage and not allow that to be developed?
Yeah, two responses to that, Your Honor. First, privity and collateral estoppel are legal issues. They are appropriate for determination at 12B6, and indeed deciding them at 12B6 furthers their underlying purpose. The underlying purpose of those doctrines is to preserve and promote judicial efficiency, and that's exactly why in Klein, the North Carolina Court of Appeals decided privity at the motion to dismiss phase. That's why this court did it in Weingarten. And the second thing I'd say is the hypothetical that you're positing is absolutely not this case. The district court in this case properly applied. Sorry, Your Honor.
No. I should have.
Properly applied the 12B6 standard. Took all of the factual allegations in the complaint, took them as true, drew all inferences in Housecat Magaro's favor, looked at publicly available documents or documents that were intrinsic to the complaint, necessary to the complaint, and ruled that under these facts, again, drawing all factual inferences in Housecat Magaro's favor, there is privity. There is.
Can I ask you? I have a question that sort of builds off Judge Quattlebaum's. Is this weird to be doing this at 12B6? So on page 37 of your brief, you say the district court did not abuse its discretion when it ruled these equitable claims are barred by unclean hands. And that, I will just candidly say, set off a little alarm bell in my life, because I think one of the things that I've most fundamentally internalized is that a 12B6 is always reviewed de novo, that we never, ever, ever defer to district courts on 12B6. And now you're telling me that in reviewing a district court's grant of a 12B6, I apply an abusive discretion standard of review, which just seems wrong, deeply wrong to me.
So several answers to that, Your Honor. The privity discussion is reviewed under 12B6, and the factual allegations and whether or not the judge accepted them as true is reviewed under 12B6. But once those factual allegations are set, how those factors are applied in the unclean hands context is reviewed for an abuse of discretion, and that's United Bank v. Buckingham.
Is United Bank a 12B6 case?
It's a summary judgment case.
Right, so could you cite, well, okay, fair enough. And so, wait.
Subject to the same data.
Subject to the same, okay.
Standards. But again, I mean, that only goes to unclean hands. In this case, the Bar Commission found, assuming privity exists, the commission found that there was a series of bad faith ethical violations, 11 in total, a series of deception, manipulation, exploitation against two extremely vulnerable. Yes.
Something else that builds off Judge Quattlebaum's. I'm trying to decide if this matters in this case, right? So no one is actually trying to sanction the law firm, as I understand it. In the sense of no one is trying to dissolve the law firm, no one is trying to impose a monetary sanction on the law firm. We're not punishing, I mean, yes, I know money is fungible, so in some sense, yes. But I'm trying to figure out to the extent it matters in this case, and to the extent that the answer for privity purposes might be different, if the question is, are we going to punish the collective entity for the misconduct of one of its partners, versus are we simply going to say, you essentially can't reap the benefits of the wrongdoing of one of your partners? And does that matter? Does that fit doctrinally? Tell me about that.
Yes, Your Honor, that does fit doctrinally. That's the Peter H. Priest case that the district court cited at JA 323. That case held that when a law firm partner or associate commits bad faith ethical violations, that law firm is barred from collecting on equitable theories. And that, I think, completely answers your question. That is what is happening here. That's why the equitable theories.
And that would not then commit a court to later then saying that law firm itself has committed a violation of the rules of conduct, or that law firm itself should be sanctioned, or that law firm itself should have to pay damages, right?
No, that rule, the Peter H. Priest rule, only applies when a law firm seeks equitable relief against one of its former clients. The issues that the law firm is in privity with with Patrick McGarrow are the 11 bad faith ethical violations that the commission found, and those are enough to dismiss House Scott McGarrow's contract claim because the commission found that Patrick McGarrow knew that Leon and Henry lacked capacity.
But do those points, counsel, apply if the conduct is somehow outside the scope or unknown? I mean, it's unethical, but and I know you don't think that's what we have here, or that it's not, appropriately presented. Maybe you're right, but assume unequivocal, without question. I'm getting tongue-tied. That there's no that it's outside the scope of the authority of the partner, and that it's unknown to the partner. Those facts are without question undeniable. Is that case? Is there privity there?
No, there would be no privity in that case, Your Honor, because in that case, the law firm's interests and the interests of the law firm partner would diverge. Privity exists when the representation of one party's right is also the representation of the second party's right.
How do we know that didn't occur here? At the 12B6 stage, how do we know that the law firm knew about it and that what he did was within the scope of his authority? Because when you're talking about an affirmative defense being decided in a 12B6 stage, which I agree with you, you can do it, and you can do it with collateral estoppel. So no quarreling with the general principle. But how do we know that's the case here? How is that clear?
The nature of the lawsuit, what House Scott McGarrow is seeking is fees that Patrick McGarrow himself incurred, purportedly. If you look at JA 205, kind of through the next several dozen pages, it lists the fees and the costs that House Scott McGarrow is trying to recover here. Yeah. The overwhelming majority are from Patrick McGarrow, over 90%. So in this
why does that matter? I mean,
because it shows a close alignment of interest between Patrick McGarrow and House Scott McGarrow. We know that their interests don't diverge.
Because the vast majority of the work is done by him?
Yeah, because he is the embodiment of the law firm's interests for the purpose of the commission proceeding. And I'd also look to the remedy that the commission imposed here. The commission said House Scott McGarrow had to give $250,000 to Henry and Leon if he ever wanted to practice law again, and that was that the commission determined that sum by looking to the amount of money that Henry and Leon had previously paid to House Scott McGarrow. So you can see in the remedy that the commission imposed that there was a close connection between House Scott McGarrow and Patrick McGarrow.
Does it matter here? So hypothetically, right? But imagine that I thought the retainer conduct, the unethical retainer conduct, which is not just signing it with someone who is plainly incapable of doing it, but all the other things that go along with the retainer piece, that was plainly within, I think as your colleague admits, that was within the scope of his employment. But if that's true for the contract claim, does it matter whether he's in privity with respect to the loans or not? Do you understand what I'm trying to get at? So imagine a scenario where we thought the loans were outside the scope of his employment, and so he was not in privity with the law firm. But if he was in privity with respect to the retainer agreement and all the unethical conduct that went on there, wouldn't that be sufficient to resolve the contract claim?
Yes, absolutely, Your Honor.
Right, and then in theory you could turn to Peter H. and use that to deal with the equitable claims?
That's absolutely correct. The only thing that you need to resolve the contract claim is whether or not Patrick McGarrow knew that Henry and Leon lacked capacity to enter into that contract. And a predicate fact is Leon's lacking that capacity. Because he lacked that capacity, there was no contract, there was no meeting of the minds, and therefore there's no claim for House Scott McGarrow to pursue. So,
so that contract claim.
That resolves the contract claim.
Exactly.
Full stop, right? That's privity contract claim done. And then we turn to the equitable claims, and that's back to different questions, and I'm not trying to re-talk about those. But we would then have to address those in a different manner, particularly if perhaps there was not privity with respect to each of the 11 findings that were made.
Exactly. The only thing that we would need, so exactly, that's exactly right, Your Honor. For privity, you look at the issues. You look at the factual issues and the legal issues. You look at whether they were actually litigated, necessary to the commission's judgment, and done by an admission, by a agency proceeding in a judicial manner. None of those are contested here. Your Honors don't have any questions on those. But yes, that's exactly correct. When dealing with the equitable claims, all you would need to do is look to the Peter H. Priest case, which says a lawyer who commits ethical violations in bad faith, that law firm is barred from collecting fees equitably.
And your point being is that the Peter H. case doesn't depend on privity.
No,
it just depends on you being a lawyer, particularly a partner, but maybe not even a partner. That if you're the partner in the firm, privity or not, the firm can't recover. And this is back to Judge Hyten's question.
There are 3 important limitations on Peter H. Priest. The violations need to be done in bad faith, which of course happens here. It needs to be done in connection with the underlying matter, which of course happens here. And it needs to be an equitable claim, which I think directly answers Your Honor's question.
So their knowledge, scope of authority, you say don't matter?
As long as those 3 limitations are met. And to Your Honor's question, if that seems like a harsh rule, it's meant to discourage the sort of bad faith, ethical misconduct that the commission determined occurred here.
Well, and part of what mitigates it again is just that it extinguishes the firm's ability to win an equitable claim. It doesn't impose liability on the firm.
Yeah, exactly. Peter H. Priest says it's a defensive, it's something that happens defensively. That's exactly correct.
So this is the be careful who you decide to become law firm partners with principle? I mean that sincerely, that you could view it as the decision to become law firm partners with someone is consequential, and if they do some things bad, it could affect your ability to recover.
Yeah, again.
It does, though, present a different risk for a plaintiff's contingency firm than it does for other firms, though, doesn't it?
Not necessarily, Your Honor. I mean, this only applies for equitable claims, so the contingency needs to be a written contract under the North Carolina.
I hear you. Yeah, but I'm just saying that the reality is, if you're getting paid by the hour, that money's not being taken away. Here in a contingency,
Assuming they're paying in a timely manner.
Yeah, that doesn't always happen. But anyway, I'm not sure that matters under the law, but it feels like the implications of that rule can be more severe for a lawyer taking a contingency fee case who doesn't get anything to the end.
I don't think it would be more severe under a contingency fee case because
why
you still
not?
have the contractual remedy. You still have a contractual remedy under a written contract, and all contingency fees need to be in writing. So these are only for equitable claims, Your Honor. And I wouldn't see why that would be any more harsh.
Yeah, I haven't thought this issue completely out, so I may be wrong there. But I mean, in a situation here where the original contract may have been within the scope, but certain wrongful conduct is outside the scope that prevents the equitable relief, I'd have to think it through. It strikes me that it might lead to, applications that are different depending on the way you get paid. But maybe I'm wrong on that. I'll give it more thought.
Okay, Your Honors, if there are no further questions on privity, I would like to go and discuss a little bit at the outset the arguments that I heard this morning that Patrick McCarro's conduct wasn't that bad. Again, the commission found here that there was a series of bad faith ethical violations of deception, manipulation, and exploitation. I heard that from this morning that maybe that conduct wasn't so bad because there were efforts to find Henry and Leon guardians, but I want to highlight that Patrick McCarro, representing House Scott McCarro, fought those efforts tooth and nail. On the May 5th, 2017 hearing, Patrick McCarro resisted the district court's suggestion that Henry needed a guardian ad litem. Once a guardian ad litem was appointed, House Scott McCarro filed a motion for reconsideration. And then later on, once there was additional motions in place for substitution of counsel, again challenged the guardian's authority. So simply not true on this record, under the facts presented to this court, that House Scott McCarro was somehow engaged in finding Henry a guardian. It was the exact opposite. And in terms of Leon, there was a statement made about Geraldine Ransom. I want to just point out that the commission found that Geraldine Ransom was essentially placed to be Leon's guardian by House Scott McCarro, and then by Patrick.
This is just a purely question I had. What in the world is an attorney in fact?
No, exactly.
I mean that sincerely. I have no idea what that means.
I'm not sure. It's certainly not someone with power of attorney. There's not any suggestion that there was actually serving as an attorney. And we know that an attorney, in fact, wouldn't somehow render an incompetent person able to enter into a contract, because that's why Patrick Magaro again and again and again resisted the appointment of that guardian, because knowing that an incompetent person, when they have an attorney, they're not able to enter into a contract. They need a guardian in order to do that, and not an attorney or an attorney in fact. If there are no further questions,
I'm good.
we ask the court affirm. Thank you.
Thank you, counsel. Mr. Halscott, we're happy to hear from you.
Yes. Very briefly, Your Honors, just to address a couple of concerns. I've heard the weren't that bad to reference my thoughts on Patrick Magaro's behavior. That's not what I said. I said very clearly that some of these I did not think were ethical violations. I still don't have a problem with the language of the contingency fee retainer. I don't get a chance to argue that. I don't get a chance to litigate that, but I don't want to be mischaracterized on what my positions are on those things. I never would in any way, shape, or form condone any kind of ethical violations or taking advantage of a client. So I wanted to make sure we dealt with that. I also want to deal with, if we're going to be taking wholesale the findings of the DHC, then we need to take them wholesale. We can't have this diode of privity where it goes one way but doesn't go the other. Specifically, if we look at the...
But don't we think about privity on an issue-by-issue basis?
But in this issue here...
I mean, if you had a DHC proceedings where he, also, engaged a prostitute, right? We wouldn't say that, that has anything to do with the law firm, right? You wouldn't be in privity with respect to that allegation.
No, but those are separate issues. What I'm talking about here specifically...
Well, but there are 11 separate issues that they raised here, right?
Yes, there are multiple different issues.
So he could be in privity with your firm on some of them and not with others.
Possibly.
In theory.
But in the brilliance of the DHC, they already compensated for that and accounted for that. If we look at the joint appendix, page 43, and I quote, "This proceeding was not designed or intended to calculate the precise value of legal fees defendant collected, and the IC award in this case was unearned and should be returned half of it." So there was extensive testimony at the DHC about the work that Patrick Magaro did and the law firm did. And they said, okay, you may have committed these ethical violations, which they found, but they said you're still entitled to be paid. The $500,000 you got back. You got to keep $250,000 of that. And that's just on slice one, which was this very small portion.
Well, I thought they said you can keep the whole thing, right? Because that's not what DHC does. It says, he can keep the whole $500,000, right? He only has to pay $250 back if he wants to be a lawyer again.
Well, we can look at it like that, but the clear language the DHC used was they weren't trying to calculate the fees going forward. None of these ethical violations had anything to do with the legal work done during the 1983 Civil Rights Act.
I saw that statement in your brief. I guess I'll just give you a response. I read that statement as saying quite the opposite, which is, it's possible this law firm owes these gentlemen even more money. I read it not, it's possible they still owe you money. I read it as the DHC saying, we are not foreclosing the possibility that this firm owes these individuals even more money than we're ordering you to pay. Why am I wrong in reading it that way?
Well, the fact that both of us are reading this completely differently completely underscores why a 12B6 motion needed a hearing to discuss these kinds of issues, to discuss these.
But we're gonna call the people who wrote this report and ask them what they meant?
We'd have to do a fact finding. If the court wants to adopt this wholly, it's going to have to engage in fact finding. There's going to have to be evidence presented as to what the DHC actually meant. If it's unclear, the district court can't just impute what it feels like it possibly maybe sort of meant without the ability to put evidence on. If this was very clear and it said the sky is blue, okay, then the court could say the sky is blue. But we're now asking the district court to interpret various different things in here without Hallscott-Magaro having an opportunity to present evidence.
I don't think we're really, maybe I'm wrong, correct me if I am, I didn't think we were really looking at the decision, the disciplinary decision on your claim for fees or not. I thought, privity's based on, privity. There's cases that talk about equitable relief, and it may be, that some of that your firm did, some very good work in there, but isn't the effect of, if you're in privity, you don't get to get it under contract, And if, and under the equitable, as Peter H. or what, that you don't get together on the equitable claim. So, I mean, the district court is dealing with the financial implications of this stuff. The disciplinary agency is dealing with whether the conduct was ethical or not.
Partially, but the district court is relying on that in their ruling, but at the same time, they're not addressing issues that were very clear or not addressed by the DHC, including the ratification of the contract by Dwayne Gillum, who no one has made any, the ratification of the contract is not an equitable remedy.
Yeah, that you've said, and I know you feel strongly about that, but I mean, that's saying they got it wrong, and we have certain, limitations maybe on what we can do there. So.
Well, I think we do on appellate review in this case, because that was written in Judge Boyle's decision as to why it was sent away, that it wasn't there, there's no contract, but we weren't able to put on any evidence as to the discussions that Dwayne Gillum had with myself, with the law firm, with Patrick McGarrow, about yes, we want you to continue, yes, I'm going to continue with this. He's asked in open court in December of 2017 if he ratifies this. Judge Boyle's very clear about this, and he's hemming and hawing, and he says, yes, I'm going to continue forward with Hall Scott McGarrow. That's ratification, but we can't present evidence of that and have it on the record for this court to review if the 12b-6 never allowed that.
Thank you, counsel. As you well know, having been here earlier, we have a tradition here that we greatly value of coming down and greeting counsel and getting a chance to say hello in person. We are not yet back to doing that. We hope we do so in relatively short order, but we thank you for being here. We thank you for your argument. And with that, the court will adjourn us for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.